That should have it all running. Excellent. Right, well, hello again. I'm Alison Young. I'm a professor of public law. So I basically teach anything to do with what's going on with the government, human rights, how the Constitution works. And I used to do European Union law, and now I do retained EU law instead. So there you go. So what I want to talk to you a bit about today is introduce you to some aspects of the UK Constitution. Now, when I was your age, back in the kind of Stone Age, constitutional law was quite boring and quite historical, and not a lot happened. And we spent our entire time talking about a Victorian academic called Albert Venn Dicey. And we talked about his account of the Constitution, and it told us some interesting things about the UK Constitution. So first, it told us that the most important principle in the UK Constitution is something called Parliamentary Sovereignty. And what this means is that laws enacted by Parliament are the most important form of law in the land. So we're very unusual. When you go away and teach constitutional law in most other countries, we send you off to the library and we say, go away and find the book which says Constitution on it and read it, because that will have all the laws to do with the Constitution in it. We can't do that because we don't have a codified Constitution. Normally, someone will say to you, but surely if you're studying constitutional law, you can say a piece of legislation is unconstitutional and a court can come and strike it down. We can't do that either, because parliamentary sovereignty tells us that law passed by Parliament, ordinary statutes, are the most important law in the land. It also tells us that any one Parliament cannot bind its successors. And what it means by that is every single Parliament must be able to enact a law on anything that it wants. So you can't have a constitutional document that says this law is unconstitutional, because that would be contrary to parliamentary sovereignty. So most of how our Constitution works through aspects of laws, either statutes or common law, or we find it working through aspects of political things. So we have something called conventions. So conventions are not legally binding. They might tell us as to how different parts of the Constitution work, but you can't go to court and enforce them because they're not legal rules. We also have various rules that regulate how Parliament operates. So by convention, you have Prime Minister's question time every Wednesday morning. It used to be twice a week, now it's once a week. It used to be twice a week for half an hour, now it's once a week for 45 minutes. These things can change because you change the practices, and there's no law requiring things to happen in a particular way. So we used to say the UK Constitution is mostly political. It relies on political controls. It relies on people in Parliament not passing laws that would be unconstitutional. So it relies on Parliament acting in line with the wishes of the electorate, such that we won't have unconstitutional laws. So legally, you can have a law that does anything, including removing all of your human rights. Politically, we don't think they do that, so that's okay, because politics limits what Parliament will do. But recently, we've seen the Constitution become much more legal, particularly since a set of reforms that started taking place in the late 1990s under the new Labour government. So if there's one piece of constitutional law most people sort of know, even if they've not studied it, it's the Human Rights Act 1998. And this is a piece of legislation that incorporates the European Convention of Human Rights into UK law. So it made the Constitution a bit more legal. We also have devolution, and that all started in the late 1990s as well. So we don't just have a Westminster Parliament making laws, we have a Scottish Parliament, the Senedd Cymru, the Welsh Parliament, and the Northern Ireland Assembly making laws, because we now have devolution and we have legislation regulating it. And what I want to do is explore this a little bit further. How legal and how political is the UK Constitution? And does it matter? Should it be more legal? Should it be more political? And I want you to think about that by talking through what's happening at the moment. Because when I did constitutional law, not a lot happened. In the last 5 years, a lot has happened. So this is a show of hands because I don't want to record your voices without your permission, so you don't have to shout out anything. So show of hands, anyone, any idea what this is a picture of? Yeah. Ooh. See, this shows you how quickly the news changes. If I'd shown you that, 3 years ago, you'd have all been watching it. That is the UK Supreme Court. And that is a bunch of media institutions hanging outside the UK Supreme Court. They don't normally do that. The UK Supreme Court is normally fairly quiet. You don't get many people hanging around. You wouldn't even notice it's there. But in 1999, for 3 days, they were hanging outside the Supreme Court on a regular basis. And then a couple of weeks later, for the entire day, they were hanging outside the court again. Only then it was raining rather than sunny. This is the Miller case. The Miller case, the second one, which was brought by Miller and Joanna Cherry. And this took place against the backdrop of Brexit. So you can see protesters as well. So you had on one side people protesting because they felt that Parliament's powers had been removed. They wanted democracy returned. They thought the government had gone too far. On the other side, you had people protesting, saying the courts are going too far. The court shouldn't be hearing this case. There was a referendum. Get Brexit done. Get out of the court. Get on with it. Okay? And this is all against the backdrop of what was going on in Miller. So I want to explain a little bit about this case and what it tells us about the UK Constitution and what's going on at the moment. Now, there's a joke in constitutional law, so if you study law, and I will hope you do, because it's a great subject, when you study constitutional law, the joke is, if you're in an exam and you want to make an argument, but you don't know a case, just put Miller down, because it will answer it'll be authority for everything. Just put Miller, you'll be fine. It tells you everything you need to know about the UK Constitution. So what was going on in Miller? Well, here we had something called the Prorogation of Parliament, which already sounds a bit odd. So you need to understand how the UK Parliament works. So at the time of Miller, we had a UK Parliament that had 5-year fixed terms. So every 5 years, you had to elect a new set of members of Parliament, and whichever political party got the most seats, they would then form a government, and they would be in power for 5 years unless you use special measures to have an early parliamentary general election. Now, within this 5-year fixed term, Parliament has something called sessions, and these sessions normally last for a year. And at the beginning of the session, the Queen will come to Parliament, will open Parliament and set out the government's legislative programme for that particular session. When you get to the end of the session, you prorogue Parliament. So it's a way of breaking up the sessions. When Parliament is prorogued, MPs aren't there. So they're on holiday. Parliament's suspended, they're not in Parliament, they're not holding the government to account, there's no committees having meetings to hold the government to account, and there's no legislation being enacted. Once you've prorogued Parliament, any piece of legislation that was going through Parliament to become an Act of Parliament, if it hadn't gone through all of the stages by the time you prorogue, it's gone. You've got to start again. Now, there are certain exceptions. You can use special measures to carry it over, but if you don't do that, that piece of legislation that you were trying to enact stops. It's no longer going to become an Act of Parliament. You've got to start again to make it lawful. So that's what a prorogation of Parliament is. Now, what happened in the Miller case was you had a decision to prorogue Parliament. The Prime Minister asked the Queen if he could prorogue Parliament for 5 weeks. Normally, prorogations are about a week. So this was an unusual prorogation. And the question that arose was, can we go to court to check whether this prorogation was lawful or not? So the first thing we had to think about was, are there legal controls over prorogation of Parliament? So are there laws that limit it? So you can go to court and say, this prorogation is unlawful. Or is prorogation part of our political constitution? It just gets political checks, not legal checks. Because if it's just political, then the courts can't do anything. There's no such thing as an unlawful prorogation because there are no laws governing how prorogation works. It's all done by politics. And if the politics has said it's okay, then it's okay. The second question you had to ask yourself is, if this can be subject to legal checks, is it unlawful? What's wrong with it? So it's all very well saying the law can control it, but how does the law control it? And what was legally wrong with this particular decision to prorogue Parliament? And that is what the Miller case was looking at. And it's a very unusual case because it had huge consequences. You had the media broadcasting it on a regular basis, and you had 11 members of the Supreme Court sitting on that case. There are only 12 members in total. So the closest they can get to all of them sitting is 11 of them sitting on the case. That's how important this case was. The Supreme Court have done that twice, both in cases to do with Gina Miller. So this is how important these cases are, and this is why the students joke, just put Miller down. It will answer anything you need, because these are probably the two most important constitutional law cases, at least of this century. There'll probably be others, because it's constantly changing at the moment. So we need to explore this in a little bit more detail. So the way the court deals with this is it uses principles of the common law. So the Supreme Court has to go back and say, do we have any other case law? Well, we'd not had a case before dealing with prorogation, but we do have cases that deal with how we control prerogative powers, because that's another unusual thing about prorogation. It's a power that belongs to the government, technically the Crown, because technically it's a royal prerogative, a personal prerogative of the Queen. And what we mean by a prerogative power is it's something that is historically belonged to the Crown. But it's very unusual because normally when we're talking about powers of the Crown or powers of the government, we're talking about powers given to them by legislation. So the government can set rules on immigration because legislation has been enacted giving the government the power to set immigration rules and take decisions as to who they allow into the country and who they deport from the country. So Parliament has sat down democratically and decided what power it's going to give to the government. It's not the case for prerogative powers. Prerogative powers just evolved historically. So if there's a prerogative power of prorogation, that's because historically the Crown has always had the power to prorogue Parliament. And this power is recognised by the common law, by case law. So it's not a situation where you've had a democratic body give a power to the government. It's a situation where the power has evolved over time and any limits on that power come from case law, from the courts. And that makes it quite unusual. And so people argue that you shouldn't control prerogative powers in the same way. Because we've got to think about, is it legitimate for the court to be doing this? Because I don't know if you know anything about the members of the Supreme Court. They're very nice, there's 12 of them. Not at the moment, they've got 2 that had to retire, so they're in the process of appointing replacements to take them back up to 12. If you look at them, at the moment, there's 1 woman. They're all white. And I think of the 12, I think 10 of them, were Oxbridge educated. So let's just say they're not particularly representative of the country, okay? They're not democratically elected. They're appointed. They're appointed on merit. They're appointed to the job because they're good at law, okay? Because that's the job they're doing. So should we have unelected, appointed judicial members of the judiciary, these lovely judges, telling us what the limits are of a prerogative power? Because normally, these judges are interpreting legislation enacted by a democratic body, Parliament. Parliament has voted on what powers it wants to give to the government. So if the court is checking the limits of those powers, it's upholding the will of Parliament, a democratic body. But when it's checking the limits of prerogative powers, it's doing something different. It is telling you what the principles of the UK Constitution are and ensuring the government doesn't go beyond them. But it's not looking at legislation enacted by a democratic body. So having set that background, to give you an idea of why there were so many arguments, I need to talk to you about the CCSU and Secretary of State for Civil Service case, or as we call it, the GCHQ case. So for those of you who haven't worked out what the picture is, that is the donut, the home of GCHQ. It's dead easy to find. It's signposted from Cheltenham. So if you ever want to go and visit there, off you go. Now this case was concerned with, can we have trade unions at GCHQ, which is where we have all sorts of security services checking in on communications, okay, to uphold national security. And the concern was, if we had trade unions at GCHQ, they might go on strike. And if they go on strike, that would be problematic because that could harm national security. So, but the trade unions said, but freedom of association would mean we should be able to have trade unions there because GCHQ is an employer, so why can't we have trade unions in the same way we can have trade unions in other situations? So this was what we were trying to work out in the GCHQ case. And what's important about this case is it's one of the key cases that tells us how we control prerogative powers, okay? And we draw a distinction between two different types of control. One, does the prerogative power exist? Okay, that might sound an odd question to ask, but you have to check that the government really does have the prerogative power it tells you it thinks it has. So you have to go away. Is there a prerogative power? Are they actually using a prerogative power, or have they just made it up? Second, how are they exercising this prerogative power? So we know it's there, we know it exists, but what are they doing with it? Are they breaching other principles of the law in the way in which they're exercising it? So are they using it for an improper purpose? Did they take irrelevant considerations into account? In this case, did they breach a legitimate expectation? So what had happened in the past was whenever they were discussing what was going on with the employment at GCHQ, they would consult with the unions. Understandably, the Minister of the Civil Service thought, if I'm going to ban trade unions, I'm not going to consult them first, I'm just going to ban them. So they hadn't consulted with them before banning them. And so they argued, your exercise is wrong. You've breached a legitimate expectation in the way you've used this power. And the reason this case is important is because it tells us not only can courts check whether a prerogative power exists, they can also check how it is exercised, but not all of them. And they came up with a wonderful word. And they said, we will control the way in which prerogative powers are exercised when they are justiciable. And all justiciable means is suited to be determined by the court. So it's a posh way of saying, if we think this is something that is suitable for us to check, we will check it. If not, we won't. And they're trying to distinguish between, is this legal or is this purely political? and they tried to give a list of some prerogatives they thought were purely political as opposed to legal. So, deciding to enter into a treaty, political. Declaring war on someone, political. Appointing someone Prime Minister, political. Dissolving Parliament. So when you bring a parliamentary term to an end, which used to happen before the Fixed Term Parliaments Act, political. Okay? So not ones where we can control the exercise. So that's the backdrop of the case law, looking at how we control prerogative powers that the Supreme Court had to think about when deciding this case. But by the time something comes up to the Supreme Court, it's already been heard before. So the Supreme Court also had to go away and look at these cases. Okay? Now, we had two cases that came to the Supreme Court. One brought by Gina Miller, she's the picture up at the top there, and one brought by Joanna Cherry, she's the picture just to the right. Gina Miller brought her case in the English High Court, okay? And she lost. Because the High Court said, what are you trying to do here? You're trying to tell us that the prerogative power of prorogation was used for an improper purpose. Your argument is that prorogation is supposed to be used to bring a session of Parliament to an end, get the monarch in to give the Queen's speech, and start a new legislative timetable. But you're saying that's not what the Prime Minister did here. The Prime Minister was using prorogation for a different purpose. The Prime Minister wanted Brexit, but Parliament had voted against a particular withdrawal agreement. So they were a bit stuck. Because there was a deadline coming up, Parliament didn't want to leave the European Union with no deal, and the Prime Minister didn't mind if we ended up leaving with a no deal, or at least wanted to be able to have that pressure of leaving with no deal to try and get a better deal from the European Union. So the Prime Minister was a bit stuck. So he thought, if I prorogue Parliament for 5 weeks in the 9 weeks running up to Brexit, Parliament's not there, it can't stop me from achieving Brexit. Or at least that was the allegation that was made by Gina Miller. So she was saying improper purpose. And that's a control as to how we exercise the prerogative. She wasn't saying this prerogative doesn't exist. She was saying, well, we have a prerogative power of prorogation, and it has a specific purpose, bringing a session of Parliament to an end. But I think the Prime Minister has used this for an improper purpose, to shut Parliament up and achieve Brexit, overriding the wishes of Parliament. Okay? And the High Court in England said, this is too political. This is not legal. This isn't justiciable. It's not our job to tell you what the purpose of prorogation is. That's for political controls. So we can't look at it. So Gina Miller lost. Meanwhile, in Scotland, Joanna Cherry brought a similar case, and she brought it against the Advocate General for Scotland through the Scottish courts. And she also lost at first instance, but then she went on appeal in Scotland, and she won her appeal. But her argument was slightly different. So Joanna Cherry was saying, I think there's a problem with the scope of the prerogative power. Okay? So I'm not questioning how you exercised it. I'm saying I don't think you have a prerogative power to suspend Parliament for a permanent time. There must be some kind of legal limits. Because if you could suspend Parliament for eternity through prorogation with no legal check, then you can completely wipe out democracy. Surely that can't be right. So there must be some kind of legal limit on the scope of the prerogative power of prorogation. And these must be limits to try and uphold democracy. And I think here the prorogation has gone beyond those limits. It's beyond the scope the definition of the prerogative power of prorogation. And that is a legal question, because all prerogative powers have to be checked by the court to make sure they exist. You can't say there's a prerogative power to do something. You can't just make it up. The law has to tell you that that prerogative power exists. And the law will tell you not just whether it exists or not, but what its scope is. It doesn't just say, oh yes, we have a prerogative power of prorogation. It says, this is the power of prorogation and this is its scope. This is what it allows you to do. Okay? And she won. So the Supreme Court has got to decide who's right. Was the English court right in the Gina Miller case that you can't review this prerogative power because it's too political? Or was the Scottish courts right and you could control this prerogative power because you're not thinking about how it's exercised, you're thinking about what is its scope? We're thinking about, are there legal limits? Or is this just controlled by politics? And that's why it's telling us something interesting about how the UK Constitution works. So, what happened? Well, here we have the then President of the Supreme Court, Lady Hale, complete with her now infamous spider brooch. Okay? So when she delivered the judgment of the court, she wore this dress with this brooch, and this suddenly made her famous. And there was all sorts of speculation as to whether she had deliberately chosen a spider brooch. And she will tell you, no, it's just happened to be the brooch that lives on that dress. I'll leave it up to you to decide whether you think Lady Hale deliberately chose a spider to look intimidating or just happened to have a spider on her dress. Okay. What did the Supreme Court decide? Okay. They agreed with Scotland. They said this is a control over the scope of a prerogative power. It is not someone asking us to check how this prerogative power was exercised. Now, I know these prerogative powers are historical, they've been around for a long time, but the common law, the law developed by the courts, puts limits on these prerogative powers. And she gave an explanation for why. So I've given you a quote there on your slide in orange. And what she's saying is, as well as having parliamentary sovereignty, we also have a constitutional principle of the separation of powers. And this is about understanding the relationship between different types of the government, different types of institutions of government. What are the powers of Parliament, of the executive, the government, of the judiciary, the courts? And how do we distribute power between these institutions, and how do they check on each other? And she said it's our job as the court to make sure that these institutions perform their job properly in the Constitution. If the government uses the power of prorogation to unlawfully prevent Parliament from acting, that is undermining the separation of powers. It is one institution of government, the executive, our government, saying, I'm going to act in a way that stops another Parliament, the legislature, from working. And that undermines the separation of powers. So that's why we, the courts, can go away and check that when you say you have a prerogative power, you really do have that power, and they are not acting beyond the scope of that power. Because if you act beyond the scope of the power, you can undermine how our Constitution works. You can remove these effective checks and balances to make sure that the government acts within the proper legal scope of its powers. Okay? So Lady Hale has said, this is something we can control. There are legal limits on this power. But what are these legal limits? Because unless we know what the legal limits are, we don't know whether they acted unlawfully or not. And the judgment tells us there are two fundamental principles of the common law. Okay, fundamental principles. And they're not the only ones, they just happen to be the two that are relevant to this case. One of them we've already talked about, parliamentary sovereignty. This idea that Parliament is the most powerful and important institution in the land, that acts of Parliament are the highest form of land in the country, and that we don't have a constitution that can put legal limits on Parliament's legislation. But what the Supreme Court also said was parliamentary sovereignty is all well and good, but it also entails that Parliament can actually meet to enact laws. Because parliamentary sovereignty is a bit useless if Parliament can't be there to enact the legislation that is the most important form of law in the land. So parliamentary sovereignty doesn't just mean legislation is the most highest form of law in the land. It also entails that Parliament must be able to meet to enact it. Otherwise, it's a bit pointless. Okay? And so they also mentioned another principle, parliamentary accountability. Okay? And what parliamentary accountability is getting at is building on this idea of the separation of powers and checks and balances to make sure that the government, the legislature, the judiciary act within the proper sphere of their powers under the Constitution. And what parliamentary accountability is drawing on is the electorate votes to elect Parliament. Okay? Whichever political party has the most seats forms the government. And the government is accountable to Parliament because Parliament is accountable to the electorate. And that's how the Constitution should work. And this is what parliamentary accountability is all about. We have to make sure that the government is accountable to Parliament. So how did these principles place limit on prorogation? Well, the Supreme Court tells us that prorogation will be unlawful if it has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions. So if you prorogue Parliament in a way that frustrates or prevents Parliament from enacting legislation or holding the government to account without reasonable justification, then that will be unlawful. But also, it's not just any prorogation, because you could say, well, whenever we prorogue Parliament, we're stopping Parliament from enacting laws and holding the government to account. So what we're looking at is something that has a sufficiently serious impact. So it frustrates them or prevents them from performing their job to such an extent that it justifies the courts intervening and saying this is unlawful. Okay? So we have to ask ourselves, was this prorogation so serious that it placed a huge frustration on Parliament from performing its constitutional role? Because if that's the case, it was unlawful. And the answer is yes. Because we go back to the context. This was a decision to prorogue Parliament for 5 weeks, not 1 week or 10 days, which is normally how long prorogations have been. Not only that, it was a decision to prorogue Parliament for 5 weeks out of 9 weeks in the run-up to what has been the most fundamental change to the UK Constitution, Brexit, against a backdrop where you had disagreement in Parliament as to what kind of Brexit we wanted, what future relationship we wanted, what terms we were willing to withdraw from the EU from. And this cut within parties and across political parties. So if any of you anyone here studying A-level government and politics? Yeah. So if I say 2019 to you, you already know this was a very unusual year where lots of mad things happened in Parliament that don't normally happen, okay? And the rest of you, go talk to someone studying A-level politics. They will tell you all about why 2019 is very unusual. Lots of mad things and weird and wonderful things happened in 2019. So you had a very unusual set of circumstances with, so just to give you a flavour of 2019's key events, the largest ever defeat of the government since universal suffrage. Doesn't happen often. You had a piece of legislation that established something called a meaningful vote. So Parliament was meant to be voting on the type of withdrawal agreement. This is another aspect of the context. You had two pieces of legislation introduced by backbench MPs through, shall we say, interesting new interpretations of the standing orders that allowed sort of private members' bills, which you normally can never get through Parliament, to get through Parliament often in one day. I mean, you're talking unusual mad times and things going on in 2019. And that's the backdrop to proroguing for so long. So the Supreme Court is saying this is sufficiently unusual. This is a huge constitutional change. Legislation has given Parliament the ability to vote on this. Not only that, but when you're looking at such a huge constitutional change, surely Parliament should be having a say. You can't go away and prorogue at such an important time. That is going to be a sufficiently serious frustration of the ability of Parliament to enact legislation and to hold the government to account. But we know that they can have a reason for this. So even if it's exceptional, they can still give a justification. So did they have a justification? No. So in the classic phrase, it is impossible for the court to conclude on the evidence which has been put before them that there was any reason, let alone a good reason, to advise Her Majesty to prorogue Parliament for 5 weeks from the 9th or 12th of September until the 14th of October. We can't guess as to what your reason is. That would be bad. We can't do that. You have to give us a reason. You haven't given us a reason. So this is unlawful. Okay? Most of us weren't expecting that. Okay? We were not expecting all 11 judges of the Supreme Court to say this is unlawful. And it had huge political repercussions. Because the moment you say something is unlawful, then in English law, it is quashed. It is as if it never happened. So the Supreme Court said that prorogation order where you suspended Parliament and they all went home and there's no MPs, that never happened. It was as if you went into Parliament with a blank piece of paper. Nothing happened. No prorogation. Which meant MPs could immediately go back into Parliament. No special measures needed. Just off you go. You're allowed to sit. Off you go. Parliament never was suspended. So go back in and start enacting those laws. All those pieces of legislation that we thought had stopped have come back. Because you never prorogued. It never happened. As far as the law is concerned, this never took place. You've got to put yourself back in the situation as if it never took place. So that had huge political consequences. So though the decision was all about the law, the consequences were huge in political terms. And let's just say, not everybody was happy about this. So this is quotes from Hansard, which sets out what is recorded in Parliament. And this is quotes from the Prime Minister, and shall we just say, he isn't impressed. Okay? In fact, he got very angry. And you have this lovely thing in brackets there with interruption. And what that means is lots of members in Parliament shouting and screaming and getting very loud and angry in reaction to what the Prime Minister was saying, because the Prime Minister wasn't happy about the judgment and MPs were not happy about the Prime Minister's reaction to the judgment. But he says, as far as he is concerned, the court should never have decided this case. This is politics. Get out of politics, courts. This is not law. This is not what you should be doing. Okay? So he thinks the court was wrong to pronounce on what is essentially a political question at a time of great national controversy. This is politics. This is what I do. I'm the Prime Minister. If Parliament has said it's fine for me to prorogue, it is fine for me to prorogue. If I've asked the Queen and the Queen has not stopped me, then that is the end of it. There are no legal limits. This is just controlled by politics. Our constitution is a political constitution. You have gone too far, says the Prime Minister. So you've got two institutions, two very powerful institutions, telling you different things. The Supreme Court is saying this is legal. There are legal limits. You broke the legal limits. You went too far. You've got the Prime Minister saying, nope, you went too far. This is political. This is all regulated by politics. Go away. I mean, obviously, I'll abide by your judgment, but I don't like it. It was wrong. Okay? And it's not just institutions who disagree. We do as well. Okay? Not just these two poor, sad individuals, but general academics. So the reason they're up there is because the other picture, so one of them is me. I don't know if I look a lot older than that. I mean, I've been through a lot since 2019. I've got a lot more grey hairs, I think. It's been a trying time for constitutional lawyers, and it's still going on. I haven't had a holiday for 2.5 years. That's how bad it is. It's far too busy. The other individual is Stephen Tierney. And the reason I've put him up there is because we disagree, which is fine. He's a good friend. It's okay. We don't hate each other. But we both do the same job. Twice over. Because Stephen is a professor of public law at the University of Edinburgh. So we're both professors of public law. We are also both currently legal advisors to the House of Lords Constitution Committee. Okay? And yet we disagree on this. Because it's so controversial that there's no real agreement as to whether this should be legal or political. So the top quote is from me. And I think the Supreme Court was right. There are legal limits. It's important for the court to uphold the separation of powers in the UK Constitution. It's particularly important to ensure that the court upholds the powers of Parliament. Parliament is the democratically elected body in our Constitution, not the government. Parliament should be holding the government to account. And if the government acts in exceptional circumstances to undermine how Parliament can act, and Parliament is not in a position to do anything about it, then the courts need to be there to uphold the Constitution and uphold checks and balances. Okay? And the context of Brexit is just a context. This isn't denying Brexit. We know that. Brexit took place. It was making sure that the legal aspects of the Constitution were upheld. Stephen Tierney disagrees. He thinks this is political, and he's worried that by the court intervening in this case, the court has suddenly becoming more powerful than it should be. It's the court that is telling you what these constitutional principles are. And they may say they're long-standing principles of the UK Constitution that we can see in case law for a long time, but they're really vague. What does parliamentary accountability actually mean? What does parliamentary sovereignty actually mean? Is this really a clear limit that we can trust the courts to use? Or are they actually giving a very vague limit, intruding in an area that should be controlled by politics and setting a dangerous precedent? Are the courts too big for their boots? Are they giving themselves powers they shouldn't have and interfering with politics and undermining democracy? Okay? And that's what you need to think about. Who is right? Should there be a legal limit or just a political limit on these types of powers? And I want to put this, as a finish, in a context of what's going on now. Because we know in some senses what happened next. One thing that happened next was Brexit. But I've already mentioned 2019 was a bit of a crazy year. And one of the crazy elements of 2019 in Parliament was the European Union Withdrawal No. 2 Act 2019. A piece of legislation enacted in one day through an interesting interpretation of procedures brought by backbench and opposition MPs working together, not by the government. It's highly unusual. And what this required was Parliament, by a set deadline, either had to vote to agree to the withdrawal agreement or to vote to leave the EU with no deal. Okay? If it didn't do either of those, the Prime Minister had to ask the European Union for an extension. That's what happened. And shall we just say, he wasn't very happy about it. But the law required him to do it. Okay? Everything rolls on. We get another withdrawal agreement, and we try and get a vote to leave. However, they have to have a piece of legislation to bring the withdrawal agreement into power. And they had a vote on the timetable for passing that legislation. And they lost, which suddenly caused huge problems. Because you're trying to work out, can we actually get this law passed to implement the withdrawal agreement? So in order to get around that, the Prime Minister thought, I'm going to have a general election. Now, under the terms of the Fixed Term Parliament Act 2011, there's only two ways in which you can have an early general election. So you've got fixed term of 5 years, two ways of having an early parliamentary general election. A vote of no confidence, well, it's going to be a bit awkward for the Prime Minister to say, yes, I'm going to have a vote of no confidence in my own government. Okay? It's going to look a bit embarrassing if you do that. The other option is to ask for an early parliamentary general election. But the Fixed Term Parliament Act says you need 2/3 of all MPs to vote in favour of that. Well, he tried, and he kept not getting the 2/3 he needed. So he couldn't end Parliament and get an early general election. So he kept calling it the zombie Parliament. We're not doing anything. We're all stuck. What's going on? Something's got to change. So instead, he enacted or initiated the Early Parliamentary General Elections Act 2019, which is how you got your general election in 2019. This was a piece of legislation where you only needed a simple majority, not 2/3 of all the members of the House of Commons. It was passed. It set a date for a general election. So this is how our constitution works. Here's a piece of legislation, the Fixed Term Parliament Act, that says you need 2/3 to have an early parliamentary general election. Oh, that's all right. We'll just pass a new act, the Early Parliamentary General Elections Act, that doesn't need the 2/3 majority, essentially repealing the 2/3 majority requirement and having an early parliamentary general election. Fantastic. Okay? Dead easy to do. That's one of the consequences of parliamentary sovereignty. Because of all of these problems, the Conservative government was elected on a manifesto promise to change the constitution. And this is what it's doing at a rapid pace. Fixed Term Parliament Act has been repealed. It is no more. And I'll show you on the next slide what it's been replaced by. We're currently going through an independent review of administrative law. Why? Because the government thinks the courts have gone too far. So we need to rein their powers in. And it's not just in administrative law. There's also an independent Human Rights Act review. Why? Because the government thinks the courts have gone too far, the constitution has become too legal, so we want to rein it back and limit the extent to which courts can protect rights, and also limit the extent to which UK courts have to follow decisions of the European Court of Human Rights. That's ongoing. The Independent Review of Administrative Law has led to the Judicial Review of Courts Bill. It got its third reading yesterday. It's currently being criticised by the House of Lords who've proposed amendments. It's going back to the House of Commons. Eventually, in the next 3 or 4 weeks, that will appear. Okay? So what's happened to the Fixed Term Parliament Act? We now have the Dissolution and Calling of Parliament Act. So this is my other show of hands. This time, if you're doing A-level politics, you're not allowed, because I know what your answer is going to be. So we'll try this. Let's try everyone. Who's heard of the Dissolution and Calling of Parliament Act? Yeah, okay. Put your hand down if you're doing A-level politics. Yeah, excellent. Right, make my point. No one has heard of it unless you're studying politics. It has radically changed our constitution. We no longer have fixed terms, we have maximum terms of 5 years. We no longer have a situation where if you want to have an early general election, you have to have a vote in the House of Commons. That's gone. If the Prime Minister wants an early general election, he asks for one, the Queen has to give it to him, unless she can show by convention she can refuse. But don't worry, the government has set out dissolution principles to guide her as to when she can refuse. Okay? Nor can the courts control it, because this Act specifically removes the ability of the court to check on the dissolution of Parliament. And you might think, well, that's fine. It's returning us back to a political constitution. We should trust politicians to control when we have a general election. Or you might think, but if you can start abusing prerogative powers, and so you want the courts just to put an extreme check on there, shouldn't they also have a check over dissolution? Is it different? Still political, but dissolution leads to a general election. You get to vote. Prorogation doesn't. Okay? So what you need to be thinking about is, do we have a political or legal constitution, and does it matter? Should there be political or legal controls? We have parliamentary sovereignty, but should we? Should we move to a situation where we have more legal limits? And if you're interested in constitutional law, keep looking about what is going on. It might be that it's hard to find out news stories about the Dissolution and Calling of Parliament Act, but they're out there. Have a look, see what people think, see what you think about this change, and keep an eye on what's going on in the Human Rights Act review, and also another thing about to appear on the horizon, retained EU law is all about to change as well. So it doesn't look like I'm going to get a holiday anytime soon, because things are constantly changing. But I'm hoping what I've done is explain to you just how much is going on and giving you something to think about in terms of what's going on in our constitution at the moment and whether we want legal or political controls. So I will stop the recording there.